All right. So we're gonna going ahead and get started today. Well, welcome everyone to our annual What's New in Estate Planning seminar. This year we're doing it today by Zoom, and tomorrow we're doing it live at the Rancho Bernardo Library. And this is our annual seminar that we put on for our clients and friends to go over all the changes in the law that happened last year, and also what are the current laws, and of course looking forward into the future as much as we can predict. And so this is something that we put on every year and for many, many years. And this is something where we've reviewed all the changes in the law, cases that have come out, laws that change, legislations that has passed, and we sort of put it all together and figure out what's most important to our clients and how does it affect our estate planning side of things and doing administrations and handling probates. And so we thank all of you for coming this year, and hopefully you take a little bit of something from this. And as far as the logistics go, so I'll put the handout and the slides into the chat box. And then during the presentation, if you have a question, feel free to also enter it into the chat. And if we're able to answer it during that part of the presentation, we'll talk about it. If not, we're going to save questions for the end as well. And of course, feel free to always contact us after the presentation. And our contact information is on the screen and all over the place. And let's see. We'll go for about an hour 15, so this one's going to be a little bit faster than our normal ones, and we'll talk about why that is this year, which is actually a good thing for most people. And of course, this is our disclaimer. And so even though we'll be going over legal topics and how it might affect you, again, this is just general information. If you have any specific advice that you'd like to ask, again, you need to contact us directly.
Well, hello. I can't see myself, but I'm assured that you can see me. So I'm Roberta Robinson. I'm the founder of our firm here, Robinson and Wilson. I've been in practice for 48 years. Our office is in Rancho Bernardo. I'm a certified specialist, as is Daniel, in estate planning, trust, and probate law. And I'm the proud mother of Daniel and five wonderful grandchildren.
And my introduction. So I'm Daniel Wilson, again, also an estate planning attorney here in Rancho Bernardo, and our office handles planning estates, modifying existing ones. We do wills and trusts, and we also, after a death, will work with trustees and administering a trust, and of course, we'll handle probates as well. So we're sort of purely in the estate planning and administration world. And I'm also a certified specialist and have a Master of Laws in Taxation and try to be involved in the community. And I also do have three children myself. Okay, so as far as the topics go for today, what we always try to start off with are recent developments in taxes. So, believe it or not, in estate planning, a lot of what we're doing, even if we're not expressly stating it to the clients, is always thinking about taxes and planning and how can we minimize taxes and how could an estate be affected by taxes. And so that's where hopefully most of our clients don't have these issues. And so this is where the laws regarding estate taxes or death taxes can change somewhat frequently these times. And then, of course, what happens at death is also a big topic of discussion with taxes. And of course, being in California, we're always concerned about property taxes. So we'll go over all of those taxes as it relates to your estate while you're alive and even at death. And then the next part of the presentation, we always go over what we call case laws or recent developments and changes in the legislation. And so this is where things come up where maybe somebody had a bad estate plan or they did their own estate plan and ended up in court, and then they had to go through the court system and appeals, and eventually we could get like some Supreme Court rulings that really tell us what could have been done differently to avoid issues of having to end up in litigation. And so not only will we go over the case laws, but also general strategies that we implement in our estate planning and advice to clients on how to avoid litigation.
Our first area of tax is the federal estate tax. So this is a transfer tax, a death tax that occurs after a death on large estates. Well, what's a large estate? As of this year, January 1st, 2026, you can leave $15 million tax-free, which is a very large number. Anything over 15 million is still taxed at 40%. So we see this big pile of money here. And our example is if there is 15 million or less in the estate, there will be zero federal estate tax due. And here in California, we do not have an inheritance tax. But once the estate is over 15 million, let's say it's 16 million, there's a 40% tax on the amount over the 15 million. So 1 million taxed at 40% is $400,000. Now, this exemption has changed throughout the years. You might remember about 40 years ago, it was a $600,000 exemption. Then it moved up 1 million, 5 million, 10 million. Now we're up to 15 million. We were always worried that the law was going to end, that it was going to sunset. But now the law has been made permanent, as much as any tax law can be permanent, because we know Congress can always change the tax laws, but we have no sunset date anymore. How many estates will it really affect? Only about 0.1% in the United States, maybe 2 to 4,000 estates. It will be indexed for inflation starting next year. So let's take a look at my however slide. My however slide is don't forget the grips of inflation. There's my arrow with the grips of inflation. We know that we are living, of course, during inflationary times. I did a little calculation to see what's the difference between the 40-year ago $600,000 exemption and our now $15 million exemption. Internally, the increase has been about 8.5% per year to get it from 600 to 15 million. Well, that sounds like a pretty good number. The consumer price index, remarkably for that period, is only 2.7%. So this goes back to when I was in college. I said, I think the cost of everything's going up. I'm going to create my personal price index where I look back on what did things used to cost and what do they cost now and what is my personal rate of inflation. So I took a look at eggs, about 78 cents a dozen 40 years ago, now about $3.17. So the inflationary rate is 3.8%. Gas, I think even Daniel was surprised when I showed him this. It was 70 cents a gallon. It was 35 cents a gallon when I started driving, but that's a long time ago. Now we think maybe we're at $4.90 here in Southern California. So that's 4.8%. The homes, you know how much the homes have been going up in Southern California. There we have 40 years ago, 142,000, and now 850. And most people are saying 850, show me a house for 850, I'll buy it. It's maybe a million now. So that's 4.9%. And the one that I've always found is the most inflationary is the cost of tuition. So I went to University of California at Irvine. Daniel went to University of California at Merced. It's our star public school system in California. And about 40 years ago, it was $804 a year. Now, Daniel, you're going to be facing sending your first child to school. It's 14,436, a very high rate of inflation, about 8.18%. So I grew up, my father was in the furniture business, and we always learned the rules of financing. We always had to do the math. And the rule of 72 tells us that how long does it take to double? How long does it take to go from a home of 142,000 to 850,000? So we divide 72 by the rate of inflation. We're going to assume, let's say it's 7%. That means that everything doubles about every 10 years. So that's what I think really is the inflation rate on most estates today. So when I say 15 million is tax-free, I step back, and if I see a $7 million estate today, I'm thinking in 10 years it's going to be about $15 million. So don't let that number put you off from doing estate tax planning because of inflation. Now, if you are married, there are two people, and each person gets a $15 million exemption. That's a total of $30 million. How do you like my slide? Really artsy. So, how do you get these two exemptions? Well, up until 2010, you had to lose it, use it, or lose it. So if I was married, I had to say my exemption amount stays in trust for my spouse, who can have the use of it for the rest of his life. And when he dies, then it goes to the kids. So I used it. I put it into a trust. And that was what we had to do to preserve the exemption. But in 2010, the law changed to say I can transfer my exemption directly to my spouse. I don't have to leave a trust for him. I can leave my assets to him and he can get my exemption. That's called portability. You see this person walking with their case, taking the exemption to their spouse. How do you get the exemption? You don't get it automatically. That doesn't seem quite fair. But the government says the surviving spouse doesn't capture the exemption without doing something. A federal estate tax return has to be filed after the death, and technically there's 9 months to file it. And on that tax return, an election is made called the Dissui election. The deceased spouse's unused exemption amount, Dissui, is the election is made to transfer it to the spouse. Well, that sounds pretty easy. Can you just check the box and file the return and that's it and you get it? No. Big case this year. There has to be a disclosure of assets, pretty thorough, with valuations. So I tell people, don't be lazy. Get that list, the complete list of assets and the valuations. For many reasons, you want that valuation. Get it on the return, get it filed. You've got 9 months to file it. And just this morning, I looked up on my good friend AI, artificial intelligence, which we're all starting to use, to see how would people know they have to file this return. Safe deposit boxes aren't frozen in California. Bank accounts aren't frozen in California. Nobody tells you you need to see an attorney to find out what you need to do because we have no inheritance tax. So people would probably look for it on AI, maybe do a search like I did. What do I do when my spouse dies? And it had somewhat of a thorough discussion, but it never discussed this filing Form 706 to get the exemption transferred to the surviving spouse. So a lot of people haven't filed it and they're losing out on that exemption. So what did the government do? They said too many people are missing the 9 month deadline. It's too fast. People aren't telling people, see your lawyer, see your accountant after a death. Nobody is telling them to file this return. So the government came up with a ruling that said if it's been 5 years or less since the death, and if it was an estate under the exemption, an estate that did not need to file because it was under the limit. And remember, the limit used to be 600,000, 1 million, 5 million, 10. But if you were under the limit and you didn't file, you can get an extension to file for 5 years. So that means today, what are we? January 13th. If there was a death January 13th of 2021 or later, there's still time to file that estate tax return. And every year that we do this seminar, we have CPAs calling us. Did you say that there's 5 years we can go back and still file that return? And yes, back all the way to 2021, that return can still be filed to capture the exemption that existed in that year of death. I was, do we have time to go over one example? Yes, we do. It's my seminar. All right. I'm going to put you on page 2 of the handout. I'm going to talk about Wanda. Wanda is 70 years old and her estate is about 7.6 million. Her husband died and she's thinking, I don't really need his exemption. I'm under $5 million. And I say to Wanda, Wanda, what about inflation? In 10 years, when you're 80, you're going to be over $15 million. Let's not be short sighted. We are living in inflationary times. It's important for you to capture your husband's exemption. Let's go ahead and file the Form 706. And those forms are filed by the estate attorney or by CPAs who are familiar with estate tax returns. Well worth it. In fact, I had one CPA tell me, why wouldn't everybody file it? And I didn't have a good argument for why you wouldn't file it. So, Daniel, let's move on to the next transfer tax, which is the gift tax.
Great. And so the estate tax is something that we would focus on at death. So we think when you die, what is the size of your estate? Are you above or below the exemption? Another tax to consider, again, from an estate planning perspective, are gift taxes. So these are lifetime transfers. And very similar to how much you can have in your estate at the time of your death, it's the same amount that you can gift in your lifetime without ever paying a tax. And so this is one of the more common questions that we get from people is what if I want to give, $10,000 to my child? How do we pay the tax on that? Who pays the tax on it? And we say, fortunately, no one pays a tax on gifts unless you gift more than that exemption amount, which this year is $15 million. So this is how much you can gift in your lifetime. Per year, you can still make annual gifts that don't even count towards your lifetime gifting. So this year, it's the same as last year, which is $19,000 per person per year. And so in my case, I have three children. I feel very generous. I'd like to gift them up to the annual exclusion amount, and I could gift each of the kids $19,000. And so that's a very nice way of, transferring some assets. And since it's at or kind of below the threshold, I don't have to report it on a gift tax return, meaning the kids don't pay a tax on it. They just get it when you get the gift. And as far as reporting the gift goes, it would be on me as the donor, the person making the gift, of whether I have to report it. If it's the 19,000 or less, I don't have to report it. If I choose to make larger gifts, let's say $50,000 to each of the kids, I do have to report it on a gift tax return. So it's a fairly simple tax return that you file. It's called a Form 709 gift tax return. And this is where you're essentially just telling the IRS, I'm making this larger than the $19,000 gift to this person, and that's it. You just report the gift. I don't pay a tax on it. The recipient of the gift doesn't pay a tax on it. I just report it. Well, what's the effect of reporting it? That lifetime exclusion of $15 million, dollars, I'm actually reducing that by the size of the taxable gift. So again, if I make a gift of $50,000, I've reduced my exemption amount by about the $50,000. You actually take off the 19 first, and then the difference is what you report on is what reduces your gift. But of course, some people don't make these outright gifts, but they would still like to, help their kids or grandkids. And we always let them know you can make unlimited gifts towards medical or educational expenses, and it doesn't count against the annual gift tax exclusion or your lifetime gift amount. Meaning, if I pay directly to the provider of services, so I pay the tuition directly to the school, I pay for the health insurance directly to the provider or the surgery and all that, pay the dental bill directly to the dentist. Those don't count against the $19,000 gifts. So really, it's the government encouraging paying for medical and education expenses. And of course, you can make unlimited gifts towards charity as well. So you don't report these gifts to charity, you can just make them. Something new that is a change in the law this year are these Trump accounts. And so this is the IRS code section that has been officially created, section 530, 530A, and it's a new type of an account that you can create for a minor child, where once you set up the account, the government automatically deposits $1,000 into it. So it's kind of a free $1,000 that you can get. And then you can, and other people can make additional contributions up to, I believe it's about $5,000 per year. And so it's a way to encourage savings for minors. And these accounts are brand new. In fact, you can't even open them yet. I believe it starts July 4th of this year is we can start creating these accounts. And so again, you create the account, you get $1,000 from the government deposited into it. It's the US Treasury. And then employers can make contributions. And of course, parents, grandparents can contribute into these accounts. Once the child, the minor, turns 18 years old, they are now in control over these accounts. So it's also something to consider is how large do you want these accounts to be? Because eventually the minor child, when they turn 18, it's under their control. And the money can grow tax-free, which is one of the benefits, similar to like a savings account for college. It can grow tax-free as long as the funds are used for certain purposes. And even if it doesn't qualify for those purposes, it can still be used for them, and there's no penalties, but there may be some taxes that are paid on the growth. And so it's just a way to encourage savings. And these accounts, again, you can start opening them in starting about the middle of this year. But there's also some requirements where the child has to live in a zip code that's below, I believe, the median household income below $150,000. So there's still certain requirements in order to be able to open these accounts. And you may have heard about it in the news when the Dell family, the computer, Dell family, I think contributed what was it, $250 million into kind of the creation of these accounts. So hopefully, if there's going to be minor children born and they qualify in the next couple of years, and this is really a pilot program until 2028, that these accounts can be opened and funded and can grow for 18 years. Other than that, so that's kind of what's new this year. We have what we've had for many years are these 529 plans. So people call them college savings accounts, where similar idea is that the money can be or the account can be created for a child, money contributed into there, and then it can grow and grow and grow. And then as long as the accounts are used for the child's qualified education expenses, that the growth is tax-free. So it's a way to get tax-free growth in these accounts to pay for college and higher education. Something that actually changed last year is that even these accounts can be created for not just college, but also like secondary education in private schools. So there's opening the requirements of how the money can be used for these 529 plans. And you can contribute really per person the $19,000 per person per year. So it's something that you can contribute more than that 5,000 for the Trump accounts. Just something to know is that if you feel like you're kind of late to the game of setting up these accounts, that you can front load them. So you can put 5 years worth of gifts into these accounts. So, 5 times 19,000, whatever that number is, can be put into these accounts and it in 1 year, and you don't have to report it as a gift, again, even though you're above the 19,000. And so this is something that we've had tried and true, these 529 plans. Also, something that changed about these accounts really last year is that if there's leftover funds, some people have these larger accounts that have grown and grown and grown, or the child got, scholarships or grants and they didn't use up the funds, is that a certain amount can be rolled over into a Roth IRA for that child. And so it's another way to save for education, but also retirement at the same time. If the account has been open for at least 15 years, and then the contributions that are left over have been around for at least 5 years, so there's still certain requirements. But again, if there's leftover money in a 529, it's good to talk to hopefully, your financial advisor or accountant or sometimes estate planning attorney, just to know that there are these options to roll it over into a Roth IRA for the child. And then finally, a huge consideration in making gifts are what we call the carryover income tax basis. So many times, we have a client that says, I have maybe two houses. I live in one, my child lives in the other. Can I just give them that house? I want them to get it. I want them to be the owner of the property. Can I just make a gift to the child and they'll own the house and they'll know what it's like to own property? And we say, of course, you can do that, but something to consider is that if you make the gift of the house to the child, they will keep your income tax basis. Meaning, let's say you bought the house many, many years ago for $100,000. It's now worth $1 million. So if you gift the house to the child, that's how they receive it. So that if they ever were to sell the house, they pay the tax on the gain above the $100,000. That's the capital gains tax. Instead, if you continue to own the property, so you still have all this appreciation, but then you die owning the house, you get a new income tax basis. So if the house is worth $1 million at the time of your death, and then it goes to the child, so they inherit it kind of the more traditional way, that the property gets the new income tax basis. So going forward, if the child ever decides to sell it, they're only paying the tax on the gain after death. Whereas if they inherited it or if they received it as a gift, they pay the tax over your basis that you had. So when you die, there's no new income tax basis. So this is a huge consideration to think about when you're gifting appreciated assets to, children, grandchildren, or anyone else. And kind of an unknown tax. So again, for an estate planning perspective, we think, well, what happens at death? We have the federal estate tax. There could also be something called a generation skipping transfer tax. So this is another tax that could be due upon your death if you have a very large estate. So again, we're over that exemption of the 15 million per person or 30 million for a couple. If you're above that and you leave your estate typically in trust for the children for the rest of their lifetime, and then upon their death, it goes to their children, which is what we call a generation skipping trust. We also have to consider, is there also going to be this generation skipping transfer tax that could be due? Or if you just make a direct transfer to say from me, instead of going to my kids, I want assets to go directly to my grandchildren, could there be this extra tax that's due? So again, it's just something to know that there's many layers to estate taxes and transfer taxes that we have to consider when setting up your estate plan. Okay. And I mentioned it a second ago, as far as income taxes and what we call the cost basis. So again, when every time we're talking to a client and we're planning their estate, we're not just thinking who's the trustee, who's making medical decisions, who's getting your assets. We also have to consider, are we doing the best planning for income taxes? So again, getting back to this step up in basis, where we have the example of the house that you bought for 100,000, that's now worth 1 million. We really want to make sure we're minimizing any taxes that could be due if that asset is ever sold. So the biggest benefit of dying, unfortunately, is getting that stepped up basis. And again, it only happens with assets that you own. So again, if I've gifted the house to my child, I don't own it anymore. So there's no step up upon my death. The same thing happens with investments. So not just real estate, but stocks and things will also get a new income tax basis upon your death. And so what that does is it helps minimize any capital gains tax that would be due upon the sale of the asset. And so for most people, that's the big deal of kind of the main benefit of dying is that we're able to let them know that when the assets go to the kids, that they can liquidate the estate and not pay any taxes on the sale if it's done like the day after you pass away. Of course, the assets don't have to be sold right away after you pass away. They could, again, get the new basis and the kids hold on to them. And then if they decide to sell it in the future, they're just paying the tax on the gain after the date of death. And so we have the example here of home or stock, whether you make this lifetime gift or whether it's inherited at death, there could be a huge, $600,000 tax on the gain that could be due. And then, of course, not everything gets a new income tax basis. So the main thing would be retirement plans and annuities. So retirement plans like IRAs, 401ks, those assets and those accounts do not get a new income tax basis. Of course, if there's a Roth IRA, Roth 401k, we don't care about taxes because whoever gets that just gets it tax-free. And I believe we're also thinking again, what if somebody has already passed away? So unfortunately, we're in the situation where maybe there was a married couple, they had their one trust, so your family, revocable living trust that everyone has when they set up their estate plan. Many years ago, so prior to 2010, really, the way those trusts were set up between a married couple is it was one trust while they were both alive. Upon the death of one of them, the trust was meant to divide into two separate trusts. That's what we call an A-B trust. And when we say the trust divides, really what we're saying is that whatever the assets in the trust are, half of it go to the survivor because they already own half of it. The other half goes into an irrevocable trust that was meant to be created when the first person died. Another way to think about it, we call it this A-B trust. So A is for the alive person, B is for the buried person. The buried person's assets are now held in an irrevocable trust. Those assets typically are set up to support the surviving spouse, so they still have access to those funds and can use them for as they need. But the big deal from income tax perspective is that when the first spouse dies, generally we would say everything gets the new income tax basis, so that's great. So the house, the stocks, kind of a fresh start for tax purposes. Then when the trust divides, the survivor has their half. So let's say that holds their house. When they die, again, another new basis. So they get a double step up in basis because it happened when the first person died, and again when the second person died over the house in this example. But whatever the assets that get put into the B trust, that irrevocable trust, the buried person's trust, again, it's there to support the survivor. But when they die, they do not get a new income tax basis. Again, they don't own the assets, it belongs to the trust. And so, for unfortunately, some couples that are in that position now, where maybe the husband died decades ago, they have these two trusts. Now, there's a lot of gain in that B trust, that irrevocable trust. When the spouse dies, all that gain goes to the kids. And if they liquidate, they're paying the tax on all of it, where they don't really need to have those types of trusts anymore. They don't really need the trust that had split. Or we're still seeing today, even though it's been many years since the laws changed, is that there's still maybe married couples where they're both alive. They set up their trust many years ago, and maybe they don't really know, but the trust says it's supposed to split when the first person dies. Because that was the advice that was given many, many years ago, because that was how you minimize taxes. But because the tax laws have changed so much since then, really about 2010, most married couples probably don't want to have a trust split when the first person dies. And so hopefully if both spouses are alive, they come to their estate planning attorney, we look at the assets, the taxes, what your intentions are, and we say, nope, you don't need that anymore. Let's just keep it simple where the trust doesn't split when one of you dies. Everything just stays as one. But we're still seeing it where some people, a spouse passed away last month. They come in and we say, oh, you really should have updated your trust because now you're locked into this trust that has to split. Or the situation where one spouse died many, many years ago and they've been living with these two trusts. We think, well, what can you do about it if it doesn't really make sense for taxes anymore that you have these two trusts? Is there a way to undo it? And that brings us to the next slide.
All right, let me jump back in. So there are things you can do in your lifetime having to do with that trust for a spouse. There are things you can do at a death. And I say, everybody, hold your horses. Don't undo everything until we've thought through the advantages and disadvantages of having a trust for a spouse rather than giving them direct control, giving them everything outright. So I pull out my checklist. I created a checklist. I love checklists. And for people who are saying, should I just get rid of my trust? We go through the checklist. Yes, there is a $15 million exemption. It does adjust for inflation according to the government's calculation of inflation, and that will start in 2027. That was one of the questions. So if there's a $15 million exemption, why do I even need to have a trust? Well, number one, to avoid probate. We haven't talked about that just recently, but to avoid going to court on the transfer of a house and a brokerage account, etc. Do you want to have to go through the court system and have very large attorney's fees and a 1 year delay, or should it transfer more simply? So we don't get rid of the trust. We don't throw out the baby with the bathwater. It's what the trust says internally that we want to think about. So some people say, well, tell me the advantages of simplifying the trust. I would like my spouse to have total control over the trust, to revoke it, to amend it, to change it. They can do whatever they want with it. I want them to get the new income tax basis when they die on everything. Nothing's locked away from getting the new basis. I don't want them to have complicated administrative tasks. I don't want them to have to file an extra tax return on the trust for their spouse. Let them just have it. They file their regular 1040 return. And they'll make the Dessui election. I'll make sure they see you to make the Dessui election so they capture my exemption at my death. Well, those are all the arguments in favor of simplifying the trust. And what do we mean by simplify? We are amending the trust to delete the provisions that say the trust becomes irrevocable. We are saying that the trust remains revocable with the surviving spouse. And in an original marriage, so no children of prior marriages, sometimes that's the appropriate thing to do. Now, I always go through what are the disadvantages of amending the trust to get rid of the trust for the spouse, because these are very important. Number one, the blended family. So if I have children from a prior marriage and I give my spouse total control to change the distribution plan, I'm not sure my children of a prior marriage are going to see it. So that's one reason to keep the trust for the spouse. Another one is asset protection planning. So if my spouse lives to be very old and he shouldn't be driving anymore and he gets in a major accident and he is sued, his assets can be liable for the damage he caused, but the assets I've left in the irrevocable trust will be protected from his creditors. So that's a thought. And if my spouse needs Medi-Cal for long-term nursing care, if I give him everything, everything's going to count and it'll be a long time before he's eligible. If I leave my assets in trust for him in a certain way, they will not count. He may become more eligible quickly for Medi-Cal. What about state estate taxes? So we do have people leaving California, although I must say, after they've left, very often they come back to California. But if you go to a state like Washington, the state of Washington does have an estate tax. We have no estate tax in California, but the state of Washington does on estates over a certain amount. The last time I checked, it was $2 million. So if assets are in trust for my spouse, when he dies, those assets would not be taxed in Washington. But if I give him everything, everybody moves to Washington, everything would be subject to the Washington estate tax. And what about growth? So we do have people who have very large estates with assets that are rapidly appreciating. And in the past, often it was commercial property and rental property. Who knows? Maybe it's going to be Bitcoin and cryptocurrency. But if I have an asset that's rapidly appreciating, I want to get it into that irrevocable trust for my spouse. I'm willing to use my $15 million exemption because when he dies, it could be double, it could be triple in value, and it won't be taxed in his estate. If I give it to him, yeah, he's got my $15 million exemption, but it's frozen. After I've died, that exemption is frozen. And if those assets keep going up in value, that could be a problem for the kids later on. And then a technical reason for having that trust for my spouse is if I'm creating a generation skipping trust. In other words, it's going to support my children for the rest of their lives. And when they die, it goes to my grandchildren. That's a generation skipping trust. I can set aside $15 million in trust. And when my child dies, it will not be taxed again, no matter how large that trust has become. So that's the reason we evaluate the pluses and minuses of simplification. So there's a middle ground, which we call the disclaimer trust. It is something you amend in your lifetime that my trust says, at my death, it's up to my spouse whether to set up trust B, the spouse for his own benefit. He has 9 months to disclaim assets. And my trust says anything disclaimed goes into trust for his benefit. So a spouse can decide whether to set up a disclaimer trust. And the good news is it's a middle ground. It's a wait and see strategy. Let's see what the laws are. Let's see what the assets are worth. There's a 9 month window, and that's it. That's the cutoff, 9 months, no 5 year extra, 9 months. And you really have to trust your spouse that they're going to do the right thing. So, again, in a blended family, do you want to give your spouse the control to have control over the disclaimer? But many, many people are amending to set up disclaimer trusts. Now, after a death, all right, it's too late, baby. Somebody's died. You can't amend the trust because the person who set it up is no longer living. Who can amend it? The court can amend it. So there's my judge there. The family can petition the court to make a change to Trust B, to the trust for the spouse, that will cause Trust B to be taxed or included in the survivor's estate. You're actually trying to do this for income tax purposes. And the explanation to the judge would be, Your Honor, when we set up this AB trust way back when, uh, we didn't know mom was going to live or dad was going to live an extra 20 years, but it did happen. We didn't know the law was going to change. We set it up to minimize taxes. And right now, because of the $15 million exemption, the estate tax isn't what we're trying to minimize. We're trying to minimize the income tax. We want a new basis at death. So had the decedent been alive, because that's what the judge has to figure out, had the decedent been alive to hear this presentation, what would that person have wanted? And we prevail on the court that they wanted to do the optimal tax planning, which is now income tax planning. And if the surviving spouse agrees in writing and all the beneficiaries who are going to inherit one day agree in writing, if they consent, then we can bring it to the court and ask for the judge to enter an order to modify the trust. And we've been very successful with these modifications. We can modify it broadly to say the surviving spouse should be able to revoke the trust, amend the trust, change the beneficiaries. That's the most power you could give somebody. Or we could modify it to have a very narrow general power of appointment. And it could say, Trust B needs to be used to pay the survivor's debts at death. Hopefully, the survivor doesn't have any debt, but just by writing that sentence in, and the court writes the sentence in, that's enough to get a new basis when the survivor passes away.
Great. And part of our world is not just setting up these estate plans, so creating a will and trust and power of attorney, but we also work with ongoing irrevocable trusts. So again, let's say my grandparents set up a trust, and it says everything goes to the grandchildren, and they can get it when they're 25 and 30 and 35. And the grandchildren are just, in their teens right now. So they have to wait a couple of years to really be in control of the assets. And that's where you have this irrevocable trust. So again, when the creator of the trust passes away, typically the trust becomes irrevocable and it's now being administered by a trustee. So maybe they set up the trustee to be one of their children to manage it for the benefit of the grandchildren. And the trustee has, investment decisions on what to do with the assets while they're in the trust. And maybe they can use the money to pay out to the kids, the grandchildren, to pay for medical bills and living expenses. So these are these ongoing irrevocable trusts that we will work with trustees on advising them. And of course, part of our job is to make sure the trustees aware of what are the taxes that could be due in these trusts. And the biggest tax that we have to be concerned about with these irrevocable trusts on an annual basis are the income taxes. So trusts, irrevocable trusts, have to file annual income tax returns. So again, this is different than your personal revocable trust. So again, I have my trust with my house and my bank accounts and investments, and those trusts are being managed by me because they're my assets. Those revocable trusts are still reporting everything under my own social security number. So that's why, even though you have your own trust, you don't file a separate tax return. You just still report everything the same. But when I die and the trust becomes irrevocable, it gets a new tax ID number, so no longer my social, and it's now this entity that's being run and it generates income. So those trusts also have to pay taxes on the income that the if the income is accumulated within the trust, meaning the trust is set up and it's got stocks and bonds and it's generating interest and dividends. The interest and dividends, if it comes into the trust, but the trust pays it out to the beneficiary. So let's say again in the example, the money goes towards the grandchild's education or medical bills or rent, property taxes, whatever. That income, even though it was earned by the trust, if it's paid out to the beneficiary pays the taxes on it. So the trust would actually issue a K-1 form. So just like you would get a K-1 distribution from like a partnership, same thing from a trust because the trust shouldn't have to pay the tax on the income. The trust didn't hold on to it. It just paid it back out like profit. And why is it better to do it that way than do the trust pay the tax on the income? Because trusts are in a income tax bracket that's compressed compared to individuals. So on the screen, it shows that anything above $16,000 worth of income in the year, if it's accumulated within the trust pays the taxes on it because it earned it and kept it. Whereas a person doesn't pay the top income tax rate of, again, 37% for a trust and an individual, but an individual doesn't pay the 37% till they have like $500,000 worth of income. And so, really, the trusts are sort of, uh, I guess the government doesn't want trusts to just accumulate income and grow and grow and grow and not, have it taxed for no reason or have it not used for anything. So they're sort of discouraging trusts from just accumulating income by having such a severe tax on them. So that's the federal income tax on a trust is the 16,000 gets you to the top rate. But again, even if the trust generates $100,000 worth of income, if in that year, if it pays it out to the beneficiary, the trust doesn't pay the tax on it, the beneficiary does. And fortunately, when we do these seminars, we are in the beginning part of the year. So if you are an accountant, a CPA, or a trustee, you're administering or involved with these irrevocable trusts, and again, it's on the calendar year end. So January through December, what was all the income that came into the trust? Maybe the trust generated $100,000 worth of income, but only paid out $50,000. So now the trust has accumulated the other 50,000 that would have to be taxed to the trust if the trustee gets that money out to the beneficiary within the terms of the trust that you're allowed to do within 65 days after December 31st. So typically it's around like March 5th. Even though it came out in 2026, the income is treated as coming out back in 2025 for tax purposes. So again, the trust doesn't pay the tax on that accumulated income. So it's always some good end of year planning to do, really before the end of the year with these irrevocable trusts is to see is there any accumulated income, but know that you actually have 65 days after the end of the year to actually distribute it out. So again, for accountants, CPAs, trustees, if you're involved with these irrevocable trusts, something to keep an eye on is do you need to get this accumulated income out of the trust and to the beneficiary? So it'd be good to speak with your attorney about that. Okay. So we're going to take a quick little break from taxes. I know we always front load these things by talking about taxes, but again, it's very important, and that's hopefully what you're coming to us for advice on is to minimize taxes. But what are some other changes in the law that happened this year? Of course, a new concept topic is cryptocurrency. Really, in our world, we call it digital financial assets, which includes crypto and NFTs and other things is that, believe it or not, California, which is typically slow in kind of getting up to speed on new assets and changes in the law with these things, we actually have a relatively kind of novel idea of saying, similar to a bank account. So let's say you have a bank account, and maybe it's just something a bank that you've had many, many years ago. You never realized you thought you closed it out, but there's some money sitting in that account, and you just don't deal with it for years and years and years because you don't even know it exists. In California, there's a rule that says if the bank hasn't heard from you from a certain number of years and you haven't talked to them, they don't know if you're alive or not. Instead of the bank holding on to that money for a period of time, they turn it over to the state to hold for a period of 3 years, and if nobody claims it within 3 years, then it belongs to the state. So that's what we have the term escheats. It belongs to the state in that case. So that's happened for many, many years for bank accounts, investments, stocks. just refund checks, anything. You can look it up online. So California has an California unclaimed property website to look for accounts or assets that maybe belong to you or belong to someone that has died that needs to be collected on. And again, if you can get to it within the 3 years, it goes back to who it belongs to. The new law says this applies to now digital assets, so like cryptocurrency. If you happen to have, an account that holds the cryptocurrency, which, Schwab, Fidelity, Vanguard, these companies now offer these things, but you haven't contacted them or had any communication for a period of 3 years, and the companies try to reach out to you, and again, there's no contact, that they will turn over the cryptocurrency in kind to the state, meaning instead of selling it and then holding on to the cash, which, with crazy fluctuation in values of Bitcoin and other cryptocurrency, that could really hurt you if you had, a couple of Bitcoin that could have been worth hundreds of thousands of dollars in the future, but they sold it for $10,000. You wish they would have held on to it. But the law says the state holds it as crypto, and again, if you can reach out to them and contact them and get it delivered back to you, you can do that through this process. But after 18 to 20 months, the state will liquidate the account, the cryptocurrency, hold on to it again for the 3 years. But then if it's still not claimed, it goes back to the state. So again, for regular bank accounts, investment accounts, we've had this for forever. So the change in the law or the new law is that it can now apply to digital assets. So we'll see again how often this comes up. Kind of part of the whole purpose of having the cryptocurrency is that you own it just by having the password and username and password in your wallet and everything. But at least it's starting to create the structure of having this for probably in our world again the this people who have deceased. So someone's passed away, the state will kind of hold on to it. So in case you don't have the wallet information that you can get it, through the state, whether it's been liquidated or not. But we even put it on the slideshow here as far as the actual website to reach out to California unclaimed property. So you can always just put in your name, cities you lived in. We'll do this for, again, like probates or estates where maybe the family didn't know too much about the assets. So we can just search up their names to see if there's unclaimed property and that maybe there are stocks that exist and things like that that we can help them collect.
So this is a very serious topic, the End of Life Option Act. It really talks about voluntary euthanasia. Can a person end their own life? Well, in 2016 in California, a law was passed that does allow someone who's terminally ill, mentally competent, over 18, who has 6 months or less to live, which is, you might be familiar with the hospice standard, to administer medication to themselves, by themselves, to terminate their life, to end their life. So it's basically to overdose on a medication. And there's a process to do this, meeting with various physicians. The physician then prescribes the medication, and the person can use it or not use it. It's not allowed for non-terminal illnesses or other grave illnesses. So, for instance, dementia, for instance. And this law was set to expire, but it's now a permanent law. And there are utilization statistics. We are in the future now. In fact, when I was thinking this morning, what does this seem like? I thought, there's a movie I saw maybe 50 years ago about people electing to terminate their own life in a beautiful room surrounded by people and music of their choice. And I had to go to artificial intelligence. It was Soylent Green, if you remember that movie. So the future is here. And we have utilization statistics. How often is this used by people, which was rather interesting. In the last 10 years, there were 6,500 prescriptions written, which for California, that's not a big part of our population. And interestingly enough, 4.3 thousand were used of the prescriptions. Isn't that interesting? So 66% of the people used it, and 34% of the people didn't use it. And I talked to a psychologist many years ago, and she said she's had patients who order the medication and it gives them a feeling of control over their destiny or their situation. And they may not actually use it, but they feel that they are in control, which is very interesting. So most people who use it are on hospice care, so probably almost all is a cancer situation. So there is this option, and if you want to talk about it, you talk about it with your physician.
And then how this comes up in our world. So again, this law has been around for many years, and it just has become permanent. Is that in your healthcare directive? So part of the estate plan is your advanced healthcare directive, which says if I can't make a medical decision for myself, I allow someone else to make the decision for me. That this does not fall under that. So another person cannot follow this end of life option act on your behalf. So it is something that you have to be able to do yourself. And so, again, how it comes up in our conversations is somebody says, if I have Alzheimer's, dementia, I saw my parents go through it, it was terrible, wasn't a life worth living, that I want somebody else to choose to end my life, and they can't. So it has to be you, making this decision for yourself and again, self-administering the medication. Okay. Whew, so we took a little break on taxes, and now we're going to jump back into it. Because now we're talking about the most important tax for everyone that seems to come up are property taxes. So if you're in California, especially Southern California, everyone is very much concerned about property taxes and what happens at death. And so this is a change in the law that happened about 6 years ago now, a little more than 6 years ago, that we still talk to every client about, comes up in every discussion, and we still feel it's very important to have in our presentations, these seminars that we put on. And it has to do with property taxes in California after you pass away, or potentially if you make a gift in your lifetime, when the property goes to children or non-children, that just what could change in the property taxes. And so the change in the law was this Proposition 19 that was passed, which changes what happens again when you die or when you make a lifetime gift. So we have the old law. So this was transfers really prior to February 16th, 2021. That's under the old law. So if a parent died, grandparent died, left asset, real property to kids, grandkids, they're locked into whatever the property tax laws were prior to February of 21. So now we're just thinking of deaths or transfers that occurred after this date. And so under the new, what's called the parent-child exclusion, the parent, so let's say I'm the parent, I can leave my house that I live in, so my primary residence, to my children. Again, I have three kids. I can leave it to all three of them. If one of them moves into the house and maintains it as their primary residence within a year after my death, they can keep the property tax bill the same that I was paying. So they can inherit my property tax bill. It is up to a certain amount. That amount is generally about $1 million above the assessed value. So again, we have our fair market value. So what could you sell the house for? Maybe the house I could sell it for $1.5 million today. That's the fair market value. The assessed value is generally what you paid for it. So if you think on your property tax bill that you get, twice a year, on the upper right-hand corner when they have like land improvements and all those things, that's where you get to the assessed value. And again, it's generally about what you paid for the property. So if I bought the house for $500,000 and it's now worth 1.5 million at the time of my death, I leave it to the kids. At least one of them moves into the house. They can keep my property tax bill the same because I'm within the $1 million of the assessed value. Uh, and so, again, that can only occur on my primary residence. So let's say I own three houses. How fortunate. I have three houses and I have three kids. I'm going to leave one house to each one of the kids. Uh, for even if the all three of them move in and live in each of the houses, if it wasn't my primary residence, they don't get to keep the property tax bill. So even if my kids move into what I had as like rental properties, those get reassessed to the date of death value. So if each of those rental properties are $1 million, doesn't matter what I was paying in property taxes, the kids are paying one property taxes based on the $1 million, so about $10,000 per year. Again, it only applies to my primary residence. So how do you capture this benefit? You have to file some forms with the county assessor. And this is actually where we're seeing a lot of people, whether they knew they were supposed to do something or not, missing this deadline because let's say the parent passes away, the child has to clean up the house. There's just a lot of stuff in the house. They got to take it all out, go through it to decide, which of the family members want these items, deal with filing the taxes, paying the bills. There's a lot of work that goes involved in administering a trust. And what if it just takes more than a year? Potentially they could blow this parent-child exclusion because you have to file what's called this homeowner's exemption form within a year after the death in order to qualify for the parent-child exclusion. So it's in our world, it's a relatively quick deadline to have to file this because not only do you have to file it, but you also have to figure out, well, who is getting the house? Are they going to move into it? And these discussions can take a while to clear up after the death of a parent. And so, unfortunately, we have many situations where somebody missed the deadline, and we have to work with them to try to see if maybe we can, maybe we took a year and a half to get this done. So maybe that year and a half, the property is reassessed. So that's what happens when you miss the deadline is the property taxes are reassessed to full fair market value. Even if the child moves in, again, if they didn't file these forms within a year, property taxes are reassessed. And some situations will come up where, again, we're past the deadline, but then we file all the paperwork and the assessor's office says, okay, going forward, your property tax bill is reduced. But for that year or year and a half, you had to pay that higher amount. And it could be pretty significant in some cases where, in Rancho Bernardo, we have like original homeowners. So they bought the house in the 60s for $50,000 or they built it themselves and they have this crazy property tax bill that they pay. We have a recent one where original homeowner in Coronado who passed away and left the house to the kids. His property tax bill, because he also had a disabled veteran exemption on it, they paid about like $600 a year in property taxes with, a $5 million house or just the land is $5 million in Coronado. So again, if they missed the deadline, property taxes would go up to like 50, $60,000. And so again, in those situations, you pay the higher property tax bill until it gets reduced, and then going forward, if it's approved, you pay the lower property tax bill. And there has been some loosening of these rules, where a main question we get is, well, what if, mom and dad own the house, they can't live there anymore, or, there's just dad by himself and he can't take care of himself, so he goes to assisted living, and we want to, inherit the house and keep the property tax bills the same. So there's an exclusion to say that even though it's your primary residence, if you don't live there because you're in a hospital or a healthcare facility, but you intended to return home, that you can keep the parent-child exclusion even after they pass away, even though maybe they weren't actually living there. And so there's again, of course, rules around that where it has to be within, I think, a year. Like you can be out of the house for a year and still qualify. And then the main, practical consideration is, well, if mom or dad's not living there, can we just rent it out and get some income to pay for their care? And of course, that makes sense to do it that way, but you could be losing out on that parent-child exclusion because if it's being rented out, you're not really intending to return home. It's not your primary residence. And so you can still lose out on the parent-child exclusion. So these are good conversations to have with your estate planning attorney, because again, you can rent it out, but if it's to like a related person, so maybe grandchild's home from college or something, or is going to be here for an extended period of time, maybe rent it out to them, get a little bit of income being generated, and the house being occupied, and still qualify for that parent-child exclusion after the parent passes away. So again, these are for transfers after that February 2021 deadline. So anything other than the parent's primary residence gets reassessed. So other rental property, a second home, commercial property, all of these things can be reassessed. And this comes up even yesterday. Just had a new client come in that had all these plans to say, I have this house that I've lived in for forever. I want it to go to my grandkids, and I'll, let my daughter live there for her lifetime, and then it goes to the grandkids. We say, okay, like that's a great plan, but when you pass away, is your daughter actually going to live there? She's like, no, she probably won't because she has her own house and family. But eventually, I just want it to go to the grandkids. And we say, well, if your daughter doesn't live there or it does go directly to the grandchildren, please know that the property taxes will be reassessed. And so that really kind of shook her world because the whole idea is that there's no mortgage on the house. Maintenance is minimal, but the property taxes right now are low. But then we say, well, what is it worth today? And let's, again, any house, 1.5, 2 million kind of thing. If it's a $2 million house, your property tax bill, or when it goes to the daughter or grandchildren, will go up to maybe $25,000 per year. And so it's really just changes how people are planning their estates for the future because they know how much it costs for them to maintain the home. But if it goes to the next generation, that could change. And so that's one of the main questions that we ask for kind of every client that we're going into this conversation about real estate and property taxes is there a chance that one or more of the children would actually want to keep the house? Because what if they don't want it? The house is going to be sold. Great, we don't care about property taxes because the house will be sold. That's the new owner's problem. But if the kids do want, if there's and of course you don't know what's going to happen, but if they do want to maybe keep the property, we just can build in flexibility as much as possible within the estate plan to say maybe we give a child, who might move into the property, what's called a right of first refusal, so they can sort of take it as part of their share of, let's say, again, I have three children and I want one of them to get the house, but I want to be equal among everyone. If the value of the house sort of exceeds what their one-third share would be, I could say, well, you can still get the house, but you have to sort of buy out the siblings. But in that situation, if it's not written into the trust that way, then it may not qualify for the parent-child exclusion. But if the trust says they get the house, but they have this right of first refusal that have to sort of buy out the siblings, but it's all within the trust, it does provide allow you to qualify for the parent-child exclusion. So again, there's just a lot of planning that can go into your trust, really, that can help minimize the changes in the property taxes after you pass away. And of course, not only do like in our world we deal with trusts, but there's other ways to do property tax planning, and that's with entities. So instead of just being this individual owner, I bought it in my name or I bought it in the name of my trust, that's one set of rules for property taxes, and that's where you have the parent-child exclusion that you have to fit into. There's a separate set of rules if you're dealing with entities, partnership, LLCs, things like that. They have their own set of rules. And so if you are purchasing, property in the future, so you can't own it yet, but if you're going to be purchasing it, you may consider, especially if it's planning on passing it down the generations, to buy it in the form of an entity, again, a partnership or like an LLC, because they have their own set of rules, and you could be a little bit more creative on how to keep the property tax bills the same throughout the generations if it's being passed down through entities.
All right, I'm back. We have a new law in California that all county recorders must send a notice by mail to every owner if there is a deed or a mortgage recorded against your property. And what they're looking for are any documents recorded against assessor parcel numbers. So we're trying to prevent fraud. What if somebody's trying to transfer your property? Daniel actually has a very good case about this. Or if somebody's trying to mortgage your property fraudulently, you will receive in the mail any document that has been recorded against your property. And if you want to know as soon as possible, you can sign up for an electronic notification. And I think every property owner should sign up for the electronic notification, and there's the website to do it, so that if anything is recorded on one of your parcels, you will know right away.
Yeah, and the situation that Roberta, or Mom as I know her, was talking about is, and I think there's a lot of advertisements either in the mail or just on TV about title lock and freezing the title so no one can steal your house. And, those are services that you're paying money for. And really what it is, it's just notifying you after something gets recorded. So you can't prevent a document from being recorded against your house, but you could be notified of when that happens. So those companies that are advertising it, they're doing essentially what is now going to be this free service of you get notified after something gets recorded. And when you sign up for it, it doesn't have to be your own property. You can put in, I think there's a limit on how many properties you can put on there per email address, but you can put in like your house, your parents' house, or if you have like a vulnerable family member that you would be worried they might sign something, you can get notified if anything gets recorded against those properties. and then take action if there's something that shouldn't have been done. So the situation that unfortunately we had to deal with is where, mom was the owner of her house without the kids knowing it, she signed a deed that transferred the ownership to herself and some company that owned it together, so that when mom died, it became the company's property, the house. And the kids had no idea about this. So after mom passed away, they, tried to deal with the house and going through the estate. And then they found out that the house was on the market already by some company that they had never heard about. So they had to get involved with, again, like litigation and elder abuse and fraud and all these things. So, of course, to backtrack, if they would have been notified it when it first happened, because it was years before mom passed away when she did that, that they probably could have taken action and avoided getting into litigation and all these other things. So it's a good thing to sign up for. I mean, I've done it for myself.
Fires. Ugh. Of course, it makes us nervous here in California. And on the news, they kept saying it's now the first anniversary from the fires in Los Angeles, which were horrible. So it's very important on your what we call fire insurance or your property homeowner's insurance. If you have a trust, you want to make sure that your trust is named as an additional insured on the policy. So you might be familiar with the fact that if you have a mortgage on the property, your lender is listed as an additional insured. That if something happens to the property, which is their security interest, they potentially have an interest in the insurance policy. Well, it's important for your trust. So it might be the Roberta Robinson Trust dated such and such is listed as an additional insured so that there can be no claim that it was owned by the trust. The insurance company could say, we're not covering the trust, we're covering you individually. Well, a revocable trust, you and the revocable trust are the same. Just get it done. Get your trust listed as an additional insured to prevent problems. And I've done this. And what I notice is that I have to check every year when my policy is issued, is my trust still listed as an additional insured? It's something that the insurance company needs to list, physically do something on the new policy. So you have to look at your policy. It is not a fun thing to do. You want to see who's insured, and usually at the very, very, very end of the policy, it lists the additional insured. So every year, make sure that your trust is on there or make a call to the insurance agent or the insurance company. You don't want this to be a problem.
Yeah, and it's not like you're getting a new policy or have to reissue, and everybody's worried about, of course, not getting insured in Southern California because of the fires. But again, you're just adding the trust as an additional insured to the current policy. And, in our world, we always just think, what is the worst case scenario? If, let's say, again, I'm the owner of my house and I died in a fire, and then the insurance pays out to my estate because they can't pay it to the trust. The trust wasn't insured. So now there's this huge payout that has to go through probate. Whereas if it was the trust was listed as an additional insured, again, the check can be paid to the trust and just be, directed into the trust and no probate or anything. So again, it's a good idea to do, and it doesn't cost you anything. All right, finally, we'll finish off with a couple of cases and topics of like litigation. So the first case is the estate of Bodman. And so in this situation, uh, the decedent, so I think the dad had 7 children and stepchildren named as his executors. So right off the bat, that's not a good idea. And if you're ever talking to your estate planning attorney, you think, oh, can I just have my kids be co-trustees or co-executors? We'll say, yes, you can do that, but is that really a good idea? And we'll go over the pros and cons. In this case, Dad named all 7 of them to do it together. I will point out that this was in a self-prepared estate plan. So that's also just something to think about is if you're preparing your own estate plan and you're not getting advice from an attorney, you might decide that it's a good idea to name all 7 kids as co-executors. But in this case, the dad died. He owned an insurance company. And so it's up to now the 7 kids to work together to deal with the insurance company of whether to keep it going or sell it off. That's part of the job of the executor. In this case, one of the children became a little too aggressive in dealing with the dad's widow, not keeping the other kids involved in the discussions, And believe it or not, this actually all happened before they were appointed as executors. So again, if you don't have a trust in your estate or your estate has to go through probate, the executor still has to be appointed by the court. So they have to submit a petition to the court to say, I or we want to become the executors, and the court can say yes, and then you get appointed. But in this case, the stepson in this case, even before being appointed as the executor, sort of held himself out as being in control over everything and didn't cooperate with the others. And now, when it came time to appoint an executor, the other siblings said, this guy's doing a bad job and he's not even an executor yet. And the court looked at the whole situation and said, yeah, you're not even going to be considered to be an executor. So he was disqualified from serving, even with his actions before being appointed as the executor. And so, really, from an estate planning perspective, when you're deciding on who to name as your trustee executor, kind of the same idea, we'll always counsel you and say, well, does it make sense to just name the oldest son, then your next in line, as they get younger? Do you want to have the co-trustees, co-executors on there? And so that's part of what we'll do is we'll advise you on whether it makes sense and what's practical, because are they going to do a good job? That's really what we want to suss out from deciding on who would be the best person to do it. And that's part of, again, what we do is so we handle probates. So if are in this situation, unfortunately, where you've passed away and you didn't have a trust, or you had some assets that weren't in the trust, that's what we call going through probate, is now the court has to get involved to oversee the administration of your estate. And it's a whole big process, and that's part of why you want to set up your estate plan to begin with, to avoid the big process of probate and really the cost of going through probate. And the costs are actually the same for any estate, or sorry, for any attorney that you decide to work with, because it's just a function of the size of the estate. It's a percentage of it. That's what the attorney's fees are, the executor's fees, the court fees. It's really all based on the size of the estate. And so, really, to help pick the right attorney is you want to work with obviously someone who's experienced, because the goal of going through probate is, if the costs are the same, is to make it go as quickly as possible. And so that's part of what we do is we try to make the process go as quickly as possible. And fortunately, in the last couple of years, in San Diego County at least, the courts are making things a little bit more streamlined, where the first petition to become the executor, we can now get that done within like kind of like a month and a half to 2 months, when before it used to take like 4 months to even be in charge of the estate. So the courts are saying, we know we don't want it to take that long. If you just do it the right way in the first place, you'll get appointed. So that's where it's very important to get that first kind of petition, approved. But we can also send things by email to the court. We have electronic filing, so everything is digital. Even when we go into court, we actually don't have to physically go downtown to the courthouse. Everything can be done remotely. So the court has kind of streamlined the process, modernized everything, and so that's part of our world, is dealing with the courts and trying to make probates go as quickly as possible.
All right. So I know we're going past our time here, but we're okay, Daniel. Zoom isn't going to bump us off, are
No,
they?
we're good. We're okay.
Okay, you've got us. What's the risk of amending a trust by yourself? This is the Packard v. Packard case. Well, Dad had a trust prepared by the attorney that said everything went to his two sons equally. He wanted it to be equal. Then he decided to change it, and his attorney changed it. He said, my house goes to one son, imagine why, Prop 19. Another asset goes to my other son. I want it to be equal. House here, stocks and bonds over here. And if there's anything left, it's divided between them equally. So it's interesting language that we put into a document. We call it sometimes a formula clause, and it's very tricky. Exactly what does it say? Well, Dad decided to amend it himself in his own handwriting. And the change that he made resulted in the son getting the cash and securities to only get half the amount. You can imagine he's thinking in halves. And maybe he thought a half of a half is half. We don't know. So the son that now is getting less after his dad died said, I'm going to court. I want a judge to review this. The intent was always to keep it equal. And that's what the judge thinks about. What was the original intent? And I want the court to make a ruling really to reform the language that my dad wrote, reform the trust so that it is in equal division. Well, somehow these boys weren't getting along very well, and the other son said, "You're contesting the trust. You're thrown out completely. You violated the no contest clause. You brought an action, you lose your entire share." Some brother, huh? So the court had to decide, was that the kind of action that would result in this brother losing his whole share under the no contest clause? And the court held no. He's just asking to reform the document according to his dad's intent. He does not lose his share. But this is a lesson about making handwritten amendments yourself to documents. While it is authorized that you can, we call it interlineate and sign and date, it's very difficult to make a clear amendment. Even when we're writing documents, it might be in my head what it should say. I write it down and then I say, ooh, this could be interpreted in different ways. I have to tighten up the language. So that's where it is of value to use your estate planning attorney to do amendments. And I know we have a person here who's asked a question, how often should I review my trust? And I like to say, of course, it's you want to change your trustee, you want to change your distribution, it needs to be reviewed, but mentally maybe keep 3 to 5 years in mind. And we do have people who are on a calendar. They said, put me on your calendar. I want to review my trust every 2 or 3 years. And we get on the phone or a Zoom or in person. I like in person. And we go through, what did it say? Has anything changed in the law? Has anything changed in your life? And it's a wise thing to do. And I find that it's actually business owners who ask to be put on the calendar because they know there are changing circumstances, and the will and the trust, it's kind of a living document that needs to be updated. So use your estate planning attorney to make amendments. Don't create a big mess. Speaking of messes, even though we're going over time, strategies to avoid litigation. There are many, many important things that happen in the planning process and in the administration process where we try to avoid contests that go to court. And we just talked about the no contest clause. In every will, in every trust, we write in a no contest clause that if anybody brings a direct contest to the terms of the document, maybe even some outside factors, they're at risk of losing their share. And some people say, don't you have to leave them $1? And it couldn't hurt to leave money to someone who you think is going to contest, because then they have to weigh, I'm going to lose that money if I lose. So that's a thought, even though you may be very mad at that person, you don't want to leave them a thing. It's a thought to prevent future lawsuits. In the trust, we often write in that a beneficiary has only 180 days to object to an accounting. So the trustee of the trust, once it's become irrevocable, must give an accounting to the beneficiaries. It must be in a certain format. You're accounting for every dollar in, every dollar out, and it has to balance, and they're entitled to see it at least once a year. Well, the law says when you give the accounting to the beneficiary, they have 3 years to contest it. Oh my gosh, that's a long time. Unless the document says it's shortened to 180 days, 6 months. So we write that clause into our trusts. What about the trustee fee? Commonly, we write the trustee fee is reasonable, what a fiduciary would charge for similar services, a professional fiduciary or corporate trustee. Well, that can be subjective. What exactly is that amount? So we tell all of our trustees, all of our executors, keep a log, keep a diary. What did you do? On what day? What kind of service was it? Was it cleaning the house? Was it putting the house up for sale? Was it reviewing a tax return? You would be compensated at different rates for the sophistication of what is being done. Some people even want us to write in, it is a 1% fee. It's 1% per year. Nothing's negotiable. So reasonable allows for flexibility. The set percentage prevents arguments. You have to decide what's more important. The handwritten letter, that has been invaluable. If you are omitting someone who is a direct heir, and that's someone on your family tree, your children, your spouse, your parents, and if you don't have those, your brothers and sisters, your nieces and nephews, your direct heirs, if they are being omitted, it's important to say that in the documents. Usually we say, I disinherit any other heirs at law. But I force my clients, let's make a family tree. I want to see who your direct heirs are, and I'm going to mention them in the document and whether they're included or not. And if they're excluded, typically I'm going to ask you to write a letter saying that is my intent that I'm excluding my daughter, Sally. And sometimes when people need to write that letter, I hear back from them that maybe they're not going to exclude Sally. It's very interesting. It's an emotional thing to write that letter. But that letter in your own handwriting, not done on the computer, plain paper, signed and dated, is used to prove that you have the capacity to write a letter, that it most likely was your intent when you wrote that letter. It's a valuable piece of evidence. And then the 120-day notification, every trustee under California law has to send a notice to all the beneficiaries under the trust and all the heirs at law. That's the family tree, even if they're not included. The notice goes out to them. Here's a copy of the trust. We usually include it. You could say they have the right to demand it, but we just give it to them. And you have 120 days, which is only 3 months, to file a lawsuit to contest the terms of the trust. So you better hop on it, because after the 120-day period, you are barred from contesting the terms of the trust. So that's an important thing to accelerate any claims against the trust, flush out anybody that might be opposing it. So all trustees, that needs to be done. Usually the attorney does it. It's a specific format to be followed. Daniel, anything you'd like to add to that?
No, I mean, so this is kind of our summary of the major changes in the law, our takeaways. And the big deal is if you haven't reviewed your estate plan in a long time, make an appointment with your attorney to review it. It's helpful to, you may not know what the changes in the law are, or you may be under sort of a misconception of what your trust says or who's in charge. It comes up very often, believe it or not, that, even if it's been only like 5 years or something, that someone thinks their plan says one thing, but when we go over the documents, it says something different, and it can be quite a shock. So you don't really want to be shocked at what previous you did to the future you. And so it's always a good idea to review it with your estate planning attorney. And we really want to thank all of you for attending the presentation and staying with us. Most of you stayed with us this whole time. And of course, everything that we're talking about today is being recorded. And so you will receive a link to watch the recording of the presentation afterwards, along with the handouts of our slides. And also we have a more detailed handout that goes over more discussions of everything we talked about in detail. And now, if you'd like, you can put any questions you have in the Q&A, and we'll just stay on as long as you want to hear us talk and have your questions answered. And if you do need to log off, again, we really thank you. And you feel free to always call or email us afterwards with any questions that come up.